La cour, the court.
Vous asseoir. Lawrence David.
Chief Justice, Honorable Justices. The central question on appeal is whether the lower courts correctly departed from la douceur. The question is now one of horizontal stare decisis. In this light, Public Interest Litigation Institute makes 3 submissions. First, evidence of significant evolution in social awareness of racial profiling can constitute a fundamental shift in the factual matrix under vertical and horizontal stare decisis. This includes evidence as to the actual impact of a precedent such as la douceur. This is reflective of the evolutionary judicial empiricism that has ensured the common law's vitality for centuries and its application under the Charter. For example, in Carter, new evidence about public attitude toward physician-assisted death inspired the court to depart from Rodriguez. In United States versus Burns, the court departed from precedents concerning extradition to face the death penalty based on, quote, shifts in society's views regarding capital punishment, end quote. In Brooks, this court overruled the precedent in Bliss because, quote, the impugned decision perpetuated inequities no longer acceptable in Canadian society, end quote. Similarly, greater evidence regarding systemic racism and racial profiling by law enforcement warrants revisitation of la douceur. This court's sensitivity to evolving social conditions reflects 2 pillars of its adjudicative ethos. First, stare decisis is not a straitjacket that condemns the law to stasis. The second is that adherence to precedent can itself generate injustice. Evidence of significant factual evolution can assist in identifying when precedent leads to injustice, including racial injustice. In this light, la douceur is ripe for revisitation. Our second submission is that the minimal impairment prong of the Oakes test is fertile ground for departing from precedent. This is relevant because the lower courts departed from la douceur's conclusion on minimal impairment in invalidating Section 636. Applying the Oakes test is a question of mixed fact and law. This court has specifically held that a fresh application of Oakes can yield different conclusions when the test is applied under a different evidentiary record. Minimal impairment is a factually suffused inquiry. This inquiry accommodates evidence of significant factual change justifying departing from precedent. New evidence may consist of policy alternatives that are less impairing than the law previously held to be minimally impairing. The new evidence can also demonstrate greater or disparate impact on charter rights, including in the deployment of police powers. Fundamentally, Section 636 is not minimally impairing because alternatives can achieve the law's objectives without such consequences. This is to require a standard of reasonable suspicion in applying Section 636 and the ancillary power it codifies. This is a minor but effective evolution in the law. Our third submission is that this court's precedents recognizing new ancillary police powers are not immune from departure. This includes la douceur. A precedent crystallizing an ancillary power may be departed from if new evidence shows that the power goes further than necessary to achieve the relevant police duty. This may include evidence of alternatives to the recognized power or evidence as to its impact on individual liberty. These considerations are equivalent to minimal impairment. Significantly, departing from precedent crystallizing an ancillary power will directly impact analysis of legislation codifying it. If la douceur is not minimally impairing, the same is true for Section 636. If Section 636 is not minimally impairing, the same is true for the ancillary power it codifies. In either case, the court may add conditions to using an ancillary power, including the power in la douceur. For Section 636, this would involve reading a requirement of reasonable grounds to suspect. Declaration under Section 52 is not absolutely required. This appeal will indeed have pan-Canadian effect. If reasonable grounds to suspect are added to la douceur, it will apply in every province that has not codified la douceur. It will also apply to every province that has codified la douceur in Section 636 and other provisions without any minimal standards. One last point on Little Sisters. If a facially neutral law empirically repeatedly results in discriminatory outcomes, the problem is the law, not discretion. Subject to any questions, thank you for your attention.
Thank you very much.